Good day, everyone, especially to you, ma'am. I'm Criscia, Autentico, and today I will discuss to you the Chapter 4 of the Philippine Tourism Laws, which is the Law on Partnership and Corporation. But before that, let me read to you this first. For any partnership to work, the element of trust is essential and is more important than the resources or skills that the partners actually bring into business. For corporations, good governance and transparency is essential because of public trust. It is from Professor Frank Cavico, Nova Southeastern University. And now, here is our topic outlined in this chapter. First is the law on partnership. Second, advantage and disadvantages of forming partnership. Third, classification of partnership. 4. Forms of partnership. 5 is dissolution and winding up of a partnership. 6. Order of liquidation for a general partnership. 7 is order of liquidation for a limited partnership. 8 is law on corporation. 9 is kinds of corporation. 10 is advantages and disadvantages of corporate organization. 11 is distinct between a partnership and corporation. 12 is dissolution of a corporation, and lastly we have the corporate liquidation. In the end of this module, our learning objectives is differentiate the various kinds of partnerships and corporations and the responsibilities of partners. Second is identify the requirements in the formation and dissolution of the partnerships and corporations. In a high-level industry like the tourism sector, it is imperative that in strictly compliance with legal requirements in order to operate as a legitimate business. Startup operations must have a strong foundation, and in order to have a strong foundation, you must start with a strong business organization, forming a partnership or a corporation industry, like the tourism industry. This chapter will represent an overview of a partnership and a corporation as a business organization. And now let's proceed to our first topic, which is the law on partnership. The law, Article 1767, by the contract of partnership, two or more persons bend themselves to contribute money, property, or industry to common fund, with the intention of dividing the profits among themselves. And the discussion of the law is a partnership is an association of two or more persons to carry on as a co-owners of a business for profit. The definition of partnerships does not include religious associations, conjugal partnerships, and others of a similar nature because a partnership, as defined by law, refers only to associations the purpose of which is to obtain profits to be distributed among the partners. A partnership contract is based on trust and confidence. Hence, the fiduciary relation in the partnerships stems from the principle of the delectus personae, wherein no one can become a partner in partnerships without the consent of all the partner or the partners. And now we have here the advantages of forming partnerships. First, it's easy to form. Second, is improved growth possibilities. Third is freedom from bureaucracy. And we also have the disadvantage of forming a partnership. First is instability. Second is difficulty in obtaining large sums of capital. 3 is firm is tied to the acts and judgment of one partner as agent. 4th is difficulty in reserving partnership ties. In classification of partnerships, we have the according to subject matters. A. Universal partnership, a partnership which or where of all the partners contribute all of the properties to the common fund and speaks on a particular purpose or subject matter, as long as the purpose in forming a partnership is to obtain profit and is no contrary to law, morals, public order, and public policy. Nowadays, seldom if none do you experience business establishments forming a universal partnership. B. Particular partnership. A particular partnership has for its object to terminate things, their use of roots or specific undertaking or the exercise of profession or vocation. The second is the according to liability. General partnership composed of general partnerships where liability extends to their personal properties. B is limited partnerships, usually attaches the word Ltd or limited at the end of the company. Or one formed by two or more persons having a members, one or more general partners, and one of the more limited partners, where the liability of latter to third persons is limited to their capital contribution. Third, we have the according to durations. A, the partnership for a fixed term is one of which the term of its existence has been agreed upon expressly or implied. The expiration of a term thus fixed for the accomplishment to the particular undertaking specified will cause to automatic dissolution of the partnerships. So let's proceed to the form of partnerships. A partnership can be in any form, even if not recorded of an office of the Securities and Exchange Commissions, except first is when is stipulated. Second is when immovable property or real rights are contributed, in which case there must be a public instrument to which attach an inventory or immovable properties and signed by the parties, otherwise the partnership is void. Third is in case of limited partnership, the parties must A. Sign and swear to a certificate which shall state, among others, the name of the partnerships adding the word limited and the character of the business. B. File for record the certificate in the Office of the Securities and Exchange Commission. Failure to comply with the foregoing formal requirements will only make the partnership general partnership. The succeeding clip is the sample of the article of partnership. We have the Article 1783 Civil Code of Philippines, Article 1843 Civil Code of Philippines, Article 1785, Article 18 Civil Code of the Philippines, Article 1771, 1773 Civil Code of the Philippines, Article 1844 Civil Code of the Philippines. Here is the sample of each article of partnership. And now let's proceed to the dissolution and winding up of a partnership. Article 1830, dissolution is caused without a violation of the agreement between the partners. A. By the termination of the definite term of particular undertaking specified in the agreement. B. By the express will of any partner who must act in good faith, with no definite term or particular undertaking is specified. C. By the express will of all the partners who have not assigned their interest or suffered them to be charged for their separate debts, either before or after the termination of any specified term of particular undertaking. Lastly, D. By the expulsion of any partner for business, bona fide in accordance with such power conferred by the agreement between the partners. 2. In contravention of the agreement between the partners where the circumstances of not permit a dissolution under any other provision of this article, by the express will of partners at any time. Number 3. By an event which makes it unlawful for business with the partnerships be carried on or their members to carry it on in partnership. 4. When a specific thing a partner had promised to contribute to the partnerships perishes before the delivery, and in case by the loss of the thing, When the partner who contributed it vary of having reserved ownership thereof has only transferred to the partnership the use of enjoyment of the same, but the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership thereof. Number 5, by the death of any partner. Number 6, by the insolvency of any partner of the partnership. 7, by the civil interdiction of any partner. And lastly, by the decree of court under the following article 100 and 17018. Proceed to the article 1831 on application by a partnership or partner. The court shall decree a dissolution whenever: first, a partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. 2, a partner becomes in any other way incapable of performing his part or partnership contract. 3, a partner has been guilty of such conduct as tend to affect prejudicially the carrying of the business. 4, a partner willingly or persistently commits breach of partnership agreement or otherwise conduct himself in matter relating to the partnership business that is not reasonably practicable to carry on the business in partnership with him. 5, the business of the partnership can only be carried on at loss. And 6 is other circumstances render dissolution equitable. On the application of the purchaser of partners' interest under Article 1813 or 1814, first, after the termination of the specific term or particular undertaking. 2, at any time, the partnership to as a partnership at will when the interest has assigned or when the charging order was issued. Let's proceed to the next topic, which is the order of liquidation of the general partnership. Article 1839. In settling accounts between the partners after dissolution, the following rules shall be observed, subject to any agreement to the contrary. The liabilities of the partnership shall rank in order of payment as follows: A, those owing to creditors other than the partners. B, those owing to partners other than for capital and profit. C, those owing to partnerships in respect of capital. And lastly, D, those owing to partnership in respect of profit. There is a taking note that the liquidation process provision applies only to general difference process to the liquidation of a limited partnership. Here is the example of the order liquidation for a general partnership. And now, let's proceed to the order of liquidation for a limited partnership. The law in Article 1863, in settling accounts for dissolution, the liabilities of the partnership shall be entitled to payment in the following order. First is those to creditors in the order of priority as provided by the law, except those to limited partners on account for their contributions and to general partners. Second, those to limited partners in respect to their share of the profit and other compensation by way of income in their contribution. Third, those to limited partners in respect to the capital of their contributions. Fourth is to those general partners other than for capital contribution. Fifth is to those general partners in respect to profit. And lastly, those general partners in respect to capital. And here is the example of the order of liquidation of the limited partnership. Let's proceed to the law on corporation. The law, Section 2, Corporation defined. A corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. Now here are the Here are the kinds of corporation. First is the stock corporation, one of which has a capital stock divided into shares and is authorized to distribute the holders of such shares or dividend of allotments to surplus profits on the basis of the shares held. A stock corporation is organized for profit. The governing body of the stock corporation is usually the board of directors. B. The non-stock corporation, one where no part of its income is distributed as dividends of its members, trustees, or officers, subject to provision of the Code on Dissolution. A non-stock corporation is one not organized for profit. The governing body is usually the board of the trustees. C is the corporation de jure, or a corporation organized in accordance with the requirements of the law. And D is the de facto corporation, a corporation where there exists of law in its corporation. E is the public corporation, one form or organized by the government or a portion of the state. It is created by own charter of the exercise of a public function. Example of this is the barangay or city or the municipality. And the F is the private corporation, one formed for some private purpose into or end. It is created by incorporation under the General Corporation Law. This includes a government-owned and controlled corporation with the original charter and the quasi-public corporation as private corporation performing public functions. G is the corporation sole, one organized for the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denominations, sector, or church. In this corporation, there is only one incorporator. H is the illusionary corporation, one organized for a charitable purpose. I is domestic corporation, a corporation formed, organized, and existing under the law of the Philippines. Lastly, we have the foreign corporation, a corporation formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in their own country or state. Here we have the advantages of corporate organization. First is a strong separate juridical personality. Second is limited liability to investors. Third is free transferability of units of ownership. Fourth is the centralized management to the board of directors. 5 is the professionalism. And lastly, we have the easier to sell small amount of stock to raise capital. And now let's proceed to it's also the disadvantages of corporate organization. We have 3. First is the extensive government regulation. Second is double taxation, and lastly, the activities are limited by charter and values. And now, let's proceed to the distinction between a partner and a corporation. First, a partner is created by the agreement of the parties, while a corporation is created by law. It is from BP 69. 2. In partnership, the liability of the partners, except limited partners, extend to their personal properties, while the liability of the stockholders in the corporation is limited only to the extent of the shares of the stock subscribed by the team or by them. Third, in partnership, without management is not agreed upon, every partner in an agent of partnership, while the power to do business and manage the affairs of the corporation is vested in the board of directors or trustees. Fourth, partnership commences of acquiring juridical personality from the moment of the execution of the contract of partnership, while a corporation commences its corporate existence only from the date of the issuance of the certificate of incorporation by the Securities and Exchange Commission. Fifth, a partnership may be organized by only 2 persons, while a corporation requires at least 5 but not more than 15 corporators to organize. Number 6. A partner or partnerships has no right of succession, while a corporation has such rights. 7 is if in a partnership, a partner cannot transfer his interest in the partnership without the consent of all the partners, while the partnership is based on the principle of dilectus personae. While in the stock corporation, a stockholder has the right to transfer his shares without the prior consent of the other stockholders. 8. A partnership may be established for any period of time stipulated by the partners, while a corporation may exist for a term of 50 years to be extended for another term not exceeding 50 years. And lastly, we have that partner may be dissolved at any time by the will of any or all of the partners, while corporation can only be dissolved with the consent of the state. And now let's proceed to the steps in the creation and organization of a corporation. First is the promotion, second is incorporation in the section 10, and lastly we have the formal organization and commencement of the business operations in section 22. Now, here is the contents of the article of incorporation. First is the name of the corporation. The name of the corporation must not be similar or confusingly similar to other corporations registered at the Securities and Exchange Commission. It must not also be patently deceptive, confusing, or contrary to existing laws. Second is the specific purposes for which the corporation has incorporated. Third is the place where the principal office of the corporation is located, which must be within the province. Fourth is the term of which corporation is to exist. The term of the corporation shall be for 50 years, which can be extended for another 50 years. And 5 is the names, the nationalities, and residences of the incorporators, and the incorporator is defined as one who institutes the steps necessary for form a corporation, and in an original member of it. The following are the minimum qualification of corporations. A natural person. B, not less than 5 but not more than 15 incorporators. 6, the names, nationality, and residences of the incorporation board of directors until the first regular directors of trustees are duly elected and qualified. The following constitutes the minimum qualification of a board director. A is he must own at least one share in his own name. When he ceases to own at least one share in his name, he automatically ceases as director. B, majority of the corporate directors must be residents of the Philippines. C, he must not have been convicted by final judgment of an offense carrying an imprisonment exceeding 6 years and the offense constituting a violation of the corporation code. Lastly, 7, the authorized capital stock and the amount of subscribed and paid by the stockholders or incorporators. It is important that at least 25% of the authorized capital stock is subscribed and 25% of the subscribed capital is paid, which is no case the paid up of capital must not be at least less than 5,000. And here is the example of sample format of article of incorporation, airline transportation business. Article of incorporation. And also this, the second one, and this, and also the undertaking to change a corporate name. And now let's proceed to the dissolution of corporation. Corporations are dissolved as follows. 1. Voluntarily, by filing the proper papers with the Securities and Exchange Commission. No hearing is required if there are no creditors affected, but a hearing is required where creditors are affected. 2. Involuntarily, upon verified complaint filed with the Securities and Exchange Commission, upon notice and hearing and on grounds authorized by law, as in the following: A. Fraud or misrepresentation as to the paid-off capital of the corporation. B. Ultra-virus acts which are persistent despite warnings, or Republic versus Security, Credit, and Acceptance Corporation in 19 Scrap 59, 1967. C. The continuous inactivity of the corporation for at least 5 years. D. Refusal to adapt or approve bylaws in PD 902A. And E is the serious dissension in the corporation. And that third is the shortening of the corporation term under Section 120 of the Corporation Code. Fourth is the expiration of the term of the corporation. And 5 is the failure to organize and commence business within 2 years from the date of the issuance of the certificate of incorporation. And or 6 is the legislative dissolution. Some government requirements in doing business as a partnership or corporation. First requirements is requirements for registration of business name under DIT or DTI. Second, for partnership, articles of partnership, birth certificate of all the partners with their 2x2 pictures. Third is for corporation, articles of incorporation, bylaws, certificate of incorporations, birth certificates of all the incorporators with their 2x2 pictures. Next is the requirements for acquiring a business permit with the city or municipal mayor. First is the barangay clearance or police clearance. Second is the certificate of registration with the DTI. Third is the articles of partnership, articles of incorporation, and bylaws. Fourth is the payment of fees, depending on the capital stock or amount of the capital declared. Fifth is the requirements for registration of business under the Bureau of International Review. And now we have to acquire a tax identification number. First is business permit from the local government unit concerned. Second is certificate of registration with the DTI. Third is article of the partnership, article of incorporation, and bylaws. Fourth is $500 annual registration fee. And lastly, we have proceed to next topic, the requirements of the registration of the social security system. To acquire, first is to acquire an SS number and PhilHealth number. Second is business permit from local government unit concerned. Third is certificate on registration with a TTI. And lastly, we have the article of partnership and articles for incorporation and bylaws. And that's all for my report. I hope you learned something. And again, I'm Criscia Autentico, and thank you.